Well, good morning, and sadly, this is the last day of the Tokyo International Law Seminar. And today we will have one lecture and one panel discussion, followed by the completion ceremony. Before beginning the session, let me make an announcement on the surveys. We have handed out copies of QR codes for the 2 surveys to follow up on this seminar, and we would like you to spare some time to fill them out. We also already sent the QR codes electronically, and we thank you for your cooperation and look forward to your feedback. We will start the first program for today, which is a lecture by Professor Shotaro HAMAMOTO. Professor HAMAMOTO is a professor at Kyoto University, and he is one of the most renowned Japanese scholars specializing in international law. He's also the president of the Japanese Society of International Law, and his expertise spans from theory and history of international law, investment law, and dispute settlement. And this is we are very privileged to invite him to the lecture today. Professor HAMAMOTO, the floor is yours.
Thank you. Good morning to all. I know that this week has been quite long, and this is the last day. You must be exhausted. So my first and perhaps the most important task today is to keep you awake until the end. I'll do my best. And please join me in discussions, because this is supposed to be a lecture, but I'd like to continue to speak from my side only, and I hope that we're going to have interesting discussions. For that purpose, I selected several interesting topics, or topics which I consider interesting. We will go through a basics, fundamentals of the state responsibility, which we are supposed to discuss. Oh, by the way, I suppose that you have received a link to this document, right? So if you can download at any moment. But the link is valid until tomorrow, so please do not forget to download the document if you wish. Of course, you are not obliged to do that. So we are first going to go through the fundamentals, the basics of the state responsibility, and then afterwards I selected 3 topics which, as I said, I consider interesting to discuss. State responsibility, particularly those issues I think that put the fundamental, the basics of state responsibility into question. Well, first, basics. I know that. I suppose that many of you have heard of the articles on state responsibility drafted by the International Law Commission. If you are experts, you are certainly you're well aware of that. And that document is considered to, at least much of the ILC documents is considered to form the customary international law. We have a number of examples of ICJ judgments, ethos, or arbitral tribunals, which consider that this reflects customary international law, this part is customary international law, this and that. So the International Law Commission's articles on state responsibility has a great success, as you see. Why is it that the ILC articles are so widely accepted? It's mainly because of its simplicity. It's quite simple. And it made an extremely complicated question of responsibility quite simple, thanks to a great 2 Italian minds, Dionizio Ancelotti and Roberto Ago. And the result is here. The principle is extremely simple and easy to understand. Article 1, every internationally wrongful act of a state entails the international responsibility of that state. If you did something wrong, you have to respond to it. You're responsible. That's it. Yeah. If you have done something wrong, then you have to respond to it. Now, what do you mean by that? You have done something wrong? Article 2, there is an internationally wrongful act of a state when conduct on existing government action or mission is attributable to a state. So act is that of a state. State must act. And that constitutes a breach of international obligation. If you act, if you're a state, suppose that you're a state, if you act and if you breach an international obligation under international law, then that constitutes a wrongful act, illegal act, unlawful act, if you will, and you're responsible for that. And reparation. If you are responsible, you have to repair. You have to repair what you have done, reparation. And you have to wipe out all the consequences of your wrongful act. And that's it. You know, the principle is if you have done something wrong, you have to respond it, and you have to wipe out all the consequences of what you have done. Great. If this is an undergraduate class of international law, I will stop here, and that's it. You know. But since you are experts, I think more interesting things should be discussed here. One of the key concepts of this ILC articles, CY, if you will, is, of course, quite well-known distinction between primary rules and secondary rules. Beware of the distinction because the people that defines primary rules and secondary rules in many ways. For example, Hans Kelsen has its own distinction. HLA Hart has his own distinction between primary and secondary rules, and ILC has its own rules. I mean, its own distinction between primary and secondary rules. And according to the International Law Commission, primary rules of international law is the content of the international obligations, the rules which define the content of international obligations, and the secondary rules is about the consequences of the breach. So this distinction helped the International Law Commission to simplify the complicated question of international law. Because, for example, question of damage. Do you think that damage has to be there in order for a state to be held responsible for its own act? That's a question long debated since the end of the 19th century, and the ILC was succeeded in putting the question aside because that's the existence or necessity of damage is a matter of primary rules and not secondary rules, which is about responsibility. Since the International Law Commission is dealing only the secondary rules, therefore it doesn't have to deal with this touchy question of the necessity or requirement of damage under the law of the state responsibility. Thanks to this distinction, ILC was able to have general rules of state responsibility, which is applicable according to the International Law Commission to all questions of international law, in all aspects of international law. When you have done something wrong, you have to respond to it and you have to repair it. Fine. Simple. What's the basic philosophy of that? The state responsibility, the law of state responsibility is based on, of course, state sovereignty and equality of states. You are equal. If you represent the state, you are equal to your colleagues. Therefore, you cannot impose your will upon the others. If you cause problems, then you have to repair it, because you cannot impose your own will. And the first great Italian mind, Dionisio Anzilotti, considered that this is purely a legal question. If you have done something wrong, you have to repair it. When you say this is of course a moral question, first of all. But according to Dionisio Anzilotti, this is a purely legal question, purely legal concept. Responsibility is about a breach of law, breach of legal rules. And it's a damage or injury caused to the international legal order. Therefore, a state which breached an international legal order has to restore the illegality or troubled legal order. Fine, okay, so far so good, but is it possible for the simple articles or simple structure of the law of state responsibility to cover all the complexities of the real world? And that is the question, and I will pick up 3 issues which may be interesting to analyze this question. The first, attribution. As I said, state is responsible for its own act, right? The act must be attributed to the state. State isn't a vague concept, it's a legal person. It cannot act as such. It must act through the physical person such as you and you, right? So your act of natural persons must be attributable to the state, which is a legal person. This is a fundamental principle. And of course, if you have studied international, you must have learned this, these articles, Article 4, 5, 8, 11, which defines in detail those kind of issues. And most fundamental of these is, of course, Article 4. Any state organ, act of any state organ is attributable to the state. It's automatic, of course. And according to one renowned lawyer, it's the most settled and least controversial issue in this law of state responsibility. An act of a state organ is attributable state. It looks quite normal. It's quite natural, evident. It doesn't really look worthwhile discussing. Well, why is it so? Why is the act of state organ is attributable to the state? Because state has a right to self-organize its state, self-determination, kind of self-determination. If you are a state, you are a sovereign state, you can organize, you have the legal power to organize your state as you like. Nobody orders you to organize your own state. You may have this organ, you may have this kind of a judiciary, you may wish to have a parliament, you may not, and it's up to you. State can organize its own state as you like. But there's a price to pay for that. If you have organized your state as you like, then you have to be responsible for your own act, your own organization. Well, fine. Let's go into the perhaps a more interesting point. First, Verein Klimaseniorinnen Schweiz. And this question has been hotly debated in the worldwide, and so many of you must be familiar with this question of climate change. I'm not going to discuss the substance of the climate change law or human rights law in relation to the climate change. And although this case has been long debated, hotly debated among experts, among citizens from the perspective of international environmental law and human rights law, today I'd like to concentrate on the state responsibility perspective, which has not been really exploited, to my regret. What is the case? What's this? What's this? This is recent judgment of the European Court of Human Rights this year, rendered this year, only a few months ago, I'm sorry. Certain citizens, seniorin, old ladies, literally speaking, or grandmothers in Switzerland brought a case to the European Court of Human Rights because they consider that what their government, their state is doing, is in breach of human rights, particularly the right to life, right to privacy, private life. What is Switzerland doing? They're complaining that Switzerland is not doing sufficiently what the Switzerland has to do to cope with climate change issues. And we basically skip all the human rights issues and concentrate on the question. According to the European Court of Human Rights, in its judgment, April 9th of this year, the Switzerland's Act constitutes a violation of Article 8 of the Convention, which is the European Convention on Human Rights. It's about respect for private and family life. Okay, that's fine. Article 4 of the Paris Agreement. I'm sure that you are familiar with at least the name of the Paris Agreement, which is one of the most important international law documents concerning climate change. And according to, under Article 4, states parties to this Paris Agreement is obliged to what? Prepare, communicate, and maintain successible nationally determined contributions that it intends to achieve. You declare how much greenhouse gases should be eliminated from your own territory, and it is you who decide the amount of reduction. Nobody obliges you to cut the emission of greenhouse gases. You decide how much deduction or elimination shall be done. And that's called the nationally determined contribution. And in the case of Switzerland, even before the adoption of the document, when the Paris Agreement was adopted 12 December 2015, and even before, Switzerland declared that Switzerland is going to cut 50% by 2030 compared to 1990 levels, corresponding to an average reduction of GHG gas emissions by 35% over the period 21-30. That was the nationally determined contributions by Switzerland. Switzerland itself decided, right? Nobody obliged Switzerland. Switzerland itself decided to do that. And that was in accordance with the Article 4, what was going to be Article 4 of the Paris Agreement. And this is before the adoption of the Paris Agreement. And after the adoption of the Paris Agreement, Swiss government submitted a bill to its parliament to implement its own pledge, nationally determined contributions. And this is a project, so draft, not the finally adopted text. This is just a draft. I'm sorry, it's in French. It can be in German, but I think the French is slightly better understood here than German. 2030, we are going to put, Switzerland is going to cut 50% of GHG gas. That was the draft bill introduced to the Swiss parliament, right? And the part of that bill contained a very interesting rules. When you replace your heating system in your house, right? When you replace or when you buy a new one, you have to introduce an environmentally friendly system, and you are allowed to you are allowed to generate 6 kilograms of CO2 per square meter. This is relatively strict rules. You are only allowed to purchase a heating system which meets this condition. Of course, this puts a considerable burden to ordinary citizens because it's about housing. And bâtiment tertiaire, that means a service sector, buildings of a service sector. And Switzerland communicated to the office or secretariat of the UNFCCC that Switzerland is going to implement what it said before the adoption of Paris Agreement, right? But since it is Switzerland, they have to go through the national referendum to do this, the direct democracy, which is somewhat peculiar to Switzerland. All the important things must go through referendum, not in the parliament, not through the parliament, but you have to put the vote of people. And Swiss people voted against this bill. They said, no, this is overly restrictive. This restricts their economic activities excessively. The vote was close, of course, 48-52, but this happens rather frequently in Switzerland. But in any case, Swiss people rejected the government proposal, or Swiss people rejected their national commitment to reduce the GHG gas to cut 50% by 2030. Well, okay, so the draft bill was rejected. Then what can they do? Well, what can the government do? They introduced a new bill, less restrictive, which is so generous to the economy that it didn't have to go through the popular vote. The parliament was able to adopt this bill according to this adopted law. Cut 1.5%, not 50%, but 1.5% every year. Okay? If you continue to cut 1.5% by year, you end up with 13% or 14% reduction, if my calculation is correct. This is my calculation, but I hope that this is correct. Not 50%, but 13% or 14%. But this was accepted by the parliament without going through the popular referendum. And those Swiss ladies were not happy about the applicants. They are not happy about this. They considered that this act or omission on the part of the state, Swiss state, constitutes a breach of Article 8 of the European Convention on Human Rights. And the court said, yes, it does constitute breach of Article 8. So where is the problem? Before going into a state responsibility aspect, perhaps we'd better look at a bit more closely to the judgment. Partial revision of the existing 2011 CO2 Act, which is this act adopted after the popular referendum. It's just 1.5%. This is not sufficient. And this law is about the period only until 2024. What will happen after 2024? The law is silent about this. So there's a silence in law. These lacunae point to a failure on the part of the respondent state, which is Switzerland, to fulfill its positive obligation derived from Article 8. Okay, let's suppose that the court is right in this. Suppose that the Switzerland breached Article 8. This is not a course of human rights, so we are not going to discuss the substance of Article 8 or interpretation of Article 8. And what happens if a state is considered to have breached the European Convention on Human Rights? Then Article 46 of the Convention applies. It's binding, and the implementation of judgment will be supervised or controlled by the Committee of Ministers of the Council of Europe, which is an international organization within which the European Court of Human Rights is established. So Switzerland has to submit a report to the Committee of Ministers how to implement the judgment according to which Swiss has breached Article 8. And before the judgment, slightly before the judgment, this is a document which was adopted. Let's go first. Let's go through this first. The document adopted by the two houses of the Swiss Parliament. Both houses of Swiss Parliament adopted the resolution to the effect that government should not comply with the judgment. The Switzerland should do nothing to implement this judgment, which is in breach of international law, perhaps, in the view of those parliamentary members. La Suisse ne voit donc aucune raison de donner d'autre suite à l'arrêt de la Cour. So, to put it simply, Switzerland has to do nothing. It is obliged to do nothing to implement the judgment. This is the resolution adopted by two houses of both houses of the Swiss Parliament. Okay. It is not, a state which is often called a rogue state. It's Switzerland. Switzerland Parliament adopted this resolution. Slightly before the adoption of the rendering of the judgment, the Swiss Parliament adopted a new legislation which is valid now, according to which Switzerland is going to cut 50% of GHG gases. Therefore, they are going to comply with what they pledged in 2015, but without submitting concrete measures. They simply say that we are going to cut 50%, but doing how? So we don't know. There's no obligation imposed upon individuals, private individuals. We saw that in previously rejected bill, according to the previously rejected bill, even the houses of ordinary people were supposed to introduce a new heating system which would be environmentally friendly, but those kind of obligations are not found in this bill. This was not able to convince the court. And as I said, the Swiss Parliament adopted a resolution according to which the government should not comply with the judgment. And to make matters even worse, a politician which belongs to a largest party in the Switzerland, it's not a small party, but the biggest political party, Switzerland, that government shall decide to withdraw from the European Convention on Human Rights. Right? Now, the European Court of Human Rights rendered their outrageous judgment. Therefore, we should withdraw from the European Convention on Human Rights. Once again, this is not anybody. This is a member of the largest political party in Switzerland. And this is seriously debated now in Switzerland. So what happened? Well, let's look at this. The question is, from the perspective of state responsibility, once again, I emphasize this. We are not discussing environmental law. We are not discussing human rights, but state responsibility. Switzerland violated Article 8. Okay. But how? What do you mean by that? Swiss people voted against the bill. Swiss people rejected the gas emission reduction by 50%. And this is a map which shows the distribution of votes in the popular referendum. And you find something interesting, perhaps not quite surprisingly. People voted for the bill, the 50% cut of GHG gases, basically lives in rich part of Switzerland. Well, Switzerland is a rich country, but those cities are exceptionally rich and big: Basel, Zurich, Bern, Lausanne, Geneva, Lucerne. If you live in an urban area and rich enough to cover those kind of costs, you vote for. And if you live in the countryside, you vote against. There's a clear division among the Swiss people in the popular referendum. And this was, of course, remarked by the court itself. This is part of the judgment, which I consider very interesting from many perspectives. The court says the intergenerational perspective underscores intergeneration. The future generation cannot be represented at this moment. Therefore, when you take measures, particularly for climate change, you have to think about the future generations. The intergenerational perspectives underscore the risk inherent in the relevant political decision-making process, namely that short-term interests and concerns may come to prevail over. Therefore, that adds justification for the possibility of a judicial review. Can anyone translate this into plain word, into plain language? What does the court say? To put it simply, bluntly. Of course, this is the court. This is a very subtle language. delicate, elegant. But to put it simply, what does it say? What does the code say? Yeah. Any ideas? The intergenerational perspective underscores the risk. There's a risk which is inherent in political decision-making process. There's a risk in political decision-making process. Because it is short-term, it takes into account short-term interests and concerns. Right? Therefore, the intervention of the judicial bodies is justified. What does it say? Plainly, please translate this into a language which can be understood by ordinary people. Yes?
Professor, I will try. Based on this paragraph that you shared, my understanding is that it's essentially said that considering the interests of intergenerational, considering the interests of government policy making with regards to future generations, it says that essentially the government policy or legislation related to, in this case, issues of climate change can be subjected to judicial review by judicial body or whatever mechanism that the country has. For instance, like, I don't know in other countries, but for instance, in our case, it's possible that there's a mechanism for certain agencies in the government to review a legislation.
Certainly. Sandra, what do you think of this? The short-term interests and concerns may come to prevail over. Short-term interests and concerns prevail over. In politics, of course. Climate change is an intergenerational issue, which means that you have to think about future generations, of course. Right? That's fine. Okay. Therefore, this question, this issue, climate change, is too important for politicians to deal with. There must be judges who intervene, because judges are able to take into account the long-term interests. And of course, it is what the judges say. And it's not really, in the case of Switzerland, however, it is not really politicians. That was the entire population, Swiss population, involved, and they voted against the bill, right? They voted against the reduction of the greenhouse gas emission. It's not the decision of the politicians, it's the Swiss people. So, Switzerland was considered to have violated Article 8. It's a human rights, right? Who violated? Whose human rights in this case? Swiss people voted against, right? Whose human rights are violated? By who? According to the European Court of Human Rights, it is a Switzerland, there has been a violation of Article 8. By whom? By Switzerland, of course, because the respondent is Switzerland, right? Respondent is Switzerland. Therefore, Switzerland was held to have violated Article 8, okay? Each state is legally obliged, if you subscribe to, if you become party to European Convention on Human Rights or any other human rights convention, to guarantee, protect, promote human rights of people within your territory and under your jurisdiction. Okay. So basically speaking, within the territory of Switzerland. And once again, people voted against the bill. People voted against the reduction of GHG gases, and Switzerland was held to be responsible for that. Whose human rights are violated? Remember that it was people who voted against. So whose human rights are violated in this case? Any ideas? Future generations. Future generations' human rights are violated by the current generation. That's a possible argument, yes, thank you. perhaps there could be many other explanations of this. Whose human rights are violated by whom? Human rights of future generations are violated by the parents and grandparents, right? Any other ideas about this? In this kind of situation, it's not the, yes, please.
Sorry to interrupt. Please use a microphone.
European community? Did you say Europe and the rest of the world?
Yes.
Yes, theoretically speaking, that's a possible argument. But as I said, under the European Convention on Human Rights, the state are obliged to promote, protect, guarantee human rights of people within its territory and under its jurisdiction. I'm sorry that the European Convention didn't use the term within its territory, but under its jurisdiction. So the Switzerland is obliged to protect human rights of those who are under Switzerland's jurisdiction. Switzerland is not obliged to protect the human rights of people, for example, under the jurisdiction of France. It's out of scope of the European Convention on Human Rights. Any ideas? Yes, please. You have only one microphone then, or a few. There's one. Please keep it. Yes. Thank you.
Work? Okay. As far as I remember, Klimaseniorinnen is the organization of women in Switzerland.
Old women.
Old women.
Seniorinnen.
Yes, senior.
So grandmothers in Switzerland. Yeah.
Yes, and then given the situation in Europe, many elderly people are dying or like died with heat and climate change. I think they're sort of like represented the sort of interest of those old elder people, especially like vulnerable to the climate change situation. So I think they could say minorities or older people vulnerable to the climate change situation in Europe or in Switzerland are sort of like victim of violation.
Yeah. Well, strictly speaking, not in Europe, but in Switzerland, because as I said, Swiss is obliged to protect human rights of people under its jurisdiction. So the majority breached the human rights of minority. That's possible argument. It frequently happens. Basically speaking, human rights of majority that do not have to be protected under international law because it's always automatically protected. But minority has to, the human rights of minority has to be protected. Well, not minority in a technical term, but however, in this case, as I said, it was Switzerland which was held responsible. Switzerland as a state which was responsible, right? But the decision was made by the majority of the people. So whose acts are attributable to the state in the present case? Switzerland Act was considered to have breached the article breached Article H. Act must be attributable to the state in order for a state to be held responsible, as I said. So whose acts are attributed to Switzerland in the present case? The court doesn't develop on this point. The court is silent. But what do you think of this? Whose acts are attributed to Switzerland? The source of the problem is the popular vote, right? Popular vote. People's acts, or majority of the people's acts, are attributed to Switzerland, and that was considered to have breached the international obligation. So in fact, as I said, and as we discussed, a majority of Switzerland or Swiss breached a minority Swiss, or current generation Swiss people breached the human rights of the future generations. It's within the story of, it's between Swiss people. But it was considered to be the state, Switzerland as a state was held responsible for this. Well, we find here some artificial character of the arguments of state responsibility. Now, Swiss people, some of the Swiss people are breaching of the human rights of other people, other Swiss people. It's a matter of 51 or 52 versus 48 in Switzerland. And this was attributed to the state. I mean, 52% of Swiss people's voting were attributed to the state. Since it is only state who can be a party to the European Convention on Human Rights, the court has to adopt this kind of artificial argument, but this represents an artificial nature of the simple structure of the the ILC's article. We now move on to another question, which also puts into question of this simple structure of the ILC articles. Reparation. This is what we have already seen. The principle is simple. When you have done something wrong, you have to repair. You have to wipe out all the consequences. Okay. The obligation is compensation, restoration, restitution. That's what the International Law Commission says, and this is widely accepted. As you know, this is quoted from a judgment of factory at Hojov, PCIJ judgment rendered almost 100 years ago, and repeated, I don't know how many times, perhaps 1,000 or tens of thousands times before the ICJ, PCIJ, ITLOS, or any other international tribunals and domestic courts. This is fully accepted. When you breach an international obligation, you're responsible for it, and you have to repair. Okay? You have to pay compensation, to put it simply. What happens when you breach the neutrality obligation then? This is what's happening now in Ukraine. There's a pretty interesting web service, Ukraine Support Tracker, where you can find which state is supporting Ukraine in which way. United States grants this amount of military assistance, weapons, armed systems, cyber military systems. Germany does similar, the United Kingdom, Canada, Denmark, Netherlands, Sweden, France. EU, as an international organization, has no armies, therefore there's no military assistance from the European Union. And from Japan, for constitutional reasons, there's no military assistance. However, there are quite a few financial support from the part of Japan. Well, let's concentrate on the military aspect of the assistance. Now, tanks, infantry vehicles, this number of weapons have been supplied by these countries to Ukraine. This is a military system, a weapons system, or weapons, to be simply arms. Okay? Howitzers, the kind of weapon, were also supplied by these countries. Another examples, launch rocket systems, air defense systems. You know that a number of Western countries are supporting Ukraine in military terms, but if you look at these statistics and the figures, it's quite impressive. It's indeed they are supporting considerably with exporting or supplying arms and weapons. Evidently, Russia is not happy about this. And this is what Russia says before the Security Council last year, June 29th. The Russian representative says, today the cumulative amount of military assistance the United States and its allies have provided to Ukraine is over 55 billion USD. Okay? It's a huge amount. It was already, a year ago, already this amount. And according to Russian delegate, international law, including the provisions of the Hague Convention of 1907 and the norms of customary international law, which prohibit such actions by nuclear states, are unequivocal. Unequivocal. Therefore, Russia is saying that the Western countries, headed by the United States, are breaching the obligations under customary international law and under the 1907 Convention on neutrality. They are breaching the neutrality obligations. That's the argument advanced by Russian government. Now, suppose, for the sake of the argument, again, this is not a class of the law of armed conflicts. This is not a class of law of neutrality. This is not a class of jus in bello. Suppose, for the sake of the argument, Russia is right. Now, Western countries are breaching neutrality obligations. Then what happens? They are breaching international obligations. They are responsible for it. Therefore, they have to repair, restore, restitute. Wipe out all consequences. Is it the case? Russia says no. According to Russia, the result of the breach of international obligations on neutrality is this. Oh, sorry. Commission of such acts means that these states must lose their neutral status and will become parties to an armed conflict. Now, United States and others, United States and its company, supplying arms in violation of neutrality obligations, therefore they become parties to the armed conflict. The war exists between Ukraine and Russia. Of course, Russia doesn't qualify it as a law, but it's a special military operations. But anyway, it's an armed conflict under international law. And according to the Russian government in the Security Council, those states supplying weapons become parties to this armed conflict. Russia doesn't claim for reparation. Russia doesn't claim for restitution. Doesn't ask the United States to pay compensation or repair anything. It simply says that the United States and others have become parties to the armed conflict. Again, Switzerland. This is what the Swiss government says. Here is my rough translation. This is a report, report of Federal Council, the government, on the neutrality. Swiss is known for its neutrality, but the Swiss government here is not talking about its domestic law, but it's about international law. It's about customary international law according to Switzerland. According to Switzerland, le droit de la neutralité interdit la transmission directe. The law of neutrality prohibits, right? So states are obliged not to do this under international law, under customary international law. Switzerland cannot supply war material under international law. That's in the understanding of the Swiss government. Swiss government understands the customary international law of neutrality, prohibiting states to supply arms to parties to the armed conflict. Therefore, Switzerland offered support to Ukraine financially and some other materials, but they do not supply arms, which they consider prohibited under international law. Supply of arms prohibited under international law. That's a position of the Swiss government. Of course, you may agree or you may disagree. That's a different question. But the point is that according to Swiss government, customary international law prohibits states to do this. It's a clear obligation under international law. And you may remember that the Russian government referred to a 1907 convention on naval warfare. It doesn't cover the land warfare, but it only covers the naval warfare. But anyway, the Article 6 says, again, this is an English translation, but the authentic text is only in French. The supply of war material, un matériel de guerre quelconque, est interdite. Supply of war material of any kind whatever is forbidden. Forbidden, if you wish to stay. If you're a neutral state. So this is an obligation. According to Russia, Western states are breaching this obligation. So what's the consequence? Again, Mr. Nebenzi, Russian delegation, the supply of increasingly powerful weapon systems combined with the ongoing transfer of strike data to Kiev and training of soldiers means that those states are not only parties to the conflict with Russia, blah, 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 but they're also complicit in the war crimes. Okay, war crime, let's put the question of war crimes aside. According to Russia, the effect of the breach of the obligation is that those parties supplying arms become parties to the armed conflict. This is clearly not in line with what the International Law Commission says. International Law Commission says that if you breach an international law obligation, you have to repair, you have to respond to it, and you have to pay compensation. But that's not the effect of the neutrality obligation. If you breach neutrality obligation, according to Russia, again, according to Russia's position, you are not obliged to pay compensation to Russia. We are not asking, Russia is not asking for any compensation, but simply the effect is that the United States and others become parties to the armed conflicts. Now they are fighting war with Russia, according to Russia. That's the effect of the breach of neutrality obligations under international law. This kind of effect is not envisaged by the International Law Commission. Well, I said that that was the position of Russia, but it's not only Russia. For example, this is a military manual. This is an official military manual document issued by the Defense Ministry of Denmark. It says, the adversary to the state violating, again, once again, this is the breach of an obligation, violating neutrality in the conflict may subsequently take all necessary measures against that state to respond to the breach of neutrality, even if such measures involve intervention in the territory of the neutral state. Again, can anyone translate this phrase into plain language? This is a bit complicated. Well, what does the Denmark say here? If you're fighting a war, and if you consider that some other states breaches the neutrality obligation, then what can you do? The response, Danish response is here. What can you do? Please. Microphone to the.
Taking all necessary measures.
Yeah, microphone.
Hi, good morning.
Good morning.
Taking all necessary measures against the state to respond to the breach of neutrality,
Yep.
even if such measures involve intervention in the territory of the neutral state.
Yeah. Again, here, there's no discussion about compensation, no discussion about restoration, no discussion about restitution or reparation. The effect of the breach of a neutrality obligation is not the reparation, restitution, compensation. But you can immediately intervene. Yes, according to Denmark. That's Denmark's understanding of customary international law. And in history, please correct me if I'm wrong, and as far as I know, it's very difficult to prove that something does not exist. But as far as I know, no state has ever claimed a compensation or restitution, restoration, or reparation for breach of neutrality obligations. Right? And there is an obligation for neutrals clearly inscribed in the Convention, 1907 Convention, and according to Switzerland, it's a customary international law. And according to Russia, Denmark, customary international. Russia is customary international. So many states consider that neutrality is obligation under international law. But neutrality obligation, the breach of neutrality obligation does not result in the obligation to repair or restitute. Do you think that the International Law Commission was wrong in saying that the effect of the wrongful act is reparation, or only reparation? Yes, please. So,
Violation of its neutrality during the First or the Second World War.
no, where in the Treaty of Versailles? Treaty of Versailles breach of neutrality obligations. Belgium did it, something. I don't think so, but of course I may be wrong. But I don't know if you can refer me to a specific article of the Treaty of Versailles. That would be helpful. But yes, I will look at that. Thank you. But yes. Well, what do you think of this? I mean, Russia is not claiming for compensation, and Denmark is not thinking about the reparations. And no state has ever discussed the possible reparation or compensation for the breach of neutrality obligations. But neutrality obligation is an obligation under international, as we saw. Do you think that the International Law Commission was wrong in concluding that the content of responsibility that is a result of an unlawful act is the obligation to repair reparation? Yes, please.
I think they are not wrong because, in my opinion, the rule on neutrality seems more like a rule not regulating the factual act, but like it entitles a state to the legal status of neutral power. So the duties and obligations as neutral power are two sides of the same coin in this case. And if a state breaches the obligation as neutral powers, it just loses the legal status, the entitlement to the legal status of neutral powers, and also the rights attached to that status. So this is the case, like the rules regarding the neutrality is different from what the RCWA is intended to regulate. And moreover, regarding the provision of arms, it seems that the mere provision of arms is difficult to meet the so-called but-for test, which was enshrined.
But that's another question, right? That's
right.
What the IC would call the primary rules.
Sure.
Yeah. Thank you. What about this? There is an internationally wrongful act of a state which constitutes an action. The mission constitutes a breach of an international obligation. Neutrality obligation. There's a breach of obligation. What do you think of this formula then? No comment on this? As this is, well, anyone, of course, if you wish to respond to me, that'd be great. And, any comments? No? Yes, please, on the back side, please.
Thank you, Professor. So I defend ILC. So, but maybe this argument is too artificial and it's maybe too academic. And actually, reparation includes the suspension of wrongdoing and request not to do the wrongful conduct again. So maybe so Russia's claim can be considered as request for suspension and reoccurrence. Sorry, not to do take the same conduct, violating the neutrality again. I mean, sorry, it's confusing.
Yes.
I mean, so.
Suspension of unlawful acts or termination of unlawful acts. Of course, the states which are committing international wrongful act are obliged to suspend and or terminate its own unlawful act. That's fine. That's a part of responsibility. But according to SIWA, reparation consists in full reparation, meaning that wiping out all the consequences of international wrongful act. This is perhaps because of a confusion in the use of the term obligation. Yes, please. You have any comments on this? This microphone? Yes, again.
If I may add a little bit, like in my opinion, it is true that those two are using the same term, obligations, but we need to draw a distinction between the factual act, the fait internationalement illicite, and the legal act. And like this, the rule, or I would say the obligations to be entitled to a neutral power seems to be more like a conditions to that legal status rather than the obligations, like factual obligations, which prohibit the states from doing a certain act. So,
thank you for pointing out that subtle distinction. But unfortunately, the documents, relevant documents, uses the term prohibit. Actually, this is a supply of arms is prohibited in this case. It's a factual act. It's a fact. And perhaps that use of the term obligation is a bit problematic here. The term obligations means many things, in fact. If you say the state is obliged to do something, for example, in the case of neutrality, state is obliged to do this or that, or state is obliged not to do this or refrain from doing this, if you wish to stay in neutrality. If you wish to remain neutral, then you are obliged to do this. In this kind of cases, the term oblige, obligation, prohibits, does not necessarily mean what the International Law Commission has in mind. So we have to be really careful about talking about the obligations or prohibitions, because the same term obligation does not necessarily mean the same thing, as we see. I wouldn't say that the International Law Commission is responsible for that, but we should not automatically think that the breach of obligation results in reparation or compensation, obligation to of reparation or compensation. Another point concerning the reparation, and I wish to talk about full reparation in this case. There is an extremely interesting, if you are interested in the neutrality aspects, perhaps you may wish to read those kind of papers, which are extremely interesting. Finally, the last point, reparation, as we saw, and the principle is predefined. If you commit a wrongful act, you're responsible for your act, and you have to wipe out all the consequences of your illegal act. Simple, clear, fine. It's well accepted. You find many judgments, opinions of International Court of Justice and other tribunals on this aspect. Full reparation, that's one of the recent judgments of the court. It's a well accepted principle of customary international law. There's one caveat here in the ASIWA article State Responsibility. The article, ILC in the International Law Commission says that these articles deals only with the questions between state and state, between states. Paragraph 2, Article 33 says this part is without prejudice to any right arising from the international responsibility of a state which may accrue directly to any person or entity other than the state. Therefore, the ILC says that the rules concerning the reparations does not necessarily cover the situations, legal situations, which may arise between state and individuals or state and some entity, non-state entity. Therefore, the obligation to compensate, obligation to reparate, obligation to repair, obligation of reparation applies only state to state, and not necessarily state and in relation between state and individuals. And according to the International Commission, that is a question or a peculiar primary rule. The question between of the obligation of reparation between state and individuals. However, in reality, many tribunals consider that the obligation of full reparation is applicable in relation between state and individual or state and private persons, state and non-state entities. Here is one of the a recent arbitral award, but you can pick up any arbitral award dealing with the compensation or reparation. Then you automatically find the reference to Article 31, the responsible states has the obligation to make full reparation. The tribunals always, without exception, refer to this phrase. Therefore, although this is a matter between a state and a private person, which may be individual, which may be company, anyway, it's a private person, the rules of full reparation is considered to be applicable, generally speaking. Here, what one of such tribunals said, Berlin versus Ecuador. Ecuador is, of course, a state. Berlin is a company, private person, legal person. While Part 2 of the ILC articles, which sets out the legal consequences of international wrongful acts, therefore the obligation of reparation, for example, and to which Article 31 belongs, Article 31, which is about reparation, is not applicable to the international responsibility of a state vis-à-vis non-states. Of course, the tribunal is referring to Article 33.2. We have just seen it. This one. The ILC says that rules on reparation does not necessarily apply to relations between state and non-state, and that's what the tribunal says. However, it is generally accepted that ILC articles can be transposed to the context of investor-state disputes. Therefore, an obligation of reparation is applicable to the relations between states and individuals. That's what, generally speaking, tribunals say today. So, although there is an Article 33.2, the obligation to repair or obligation of reparation is considered to be applicable in relation between states and individuals. Okay, fine, that's fine, because the state is considered to have committed an internationally wrongful act in relation to individuals. The state is obliged to wipe out all consequences of its unlawful act. What's the problem? Problem often happens, and there is one extremely interesting example. There are many others, but this is one of perhaps the most interesting example, Tethyan. There was a case between a private company and Pakistan, which is a state, and I'm not going into details of case. This is not the class of investment arbitration. This is not the class of investment law, so we are not going to touch upon the issues on the investment law, although I'm pretty interested in investment law personally. The tribunal concluded, let's go directly into the conclusion. Respondent shall pay claimant, private company, USD this amount of reparation because Pakistan was considered to have committed a breach of investment treaty. This is the result. Why? To wipe out all the consequences. Tribunal was aware that Pakistan at that time was in a difficult situation. It says Pakistan emphasizes the hardship it suffered due to the delicate state of the economy that needed the $6 billion IMF extended fund facility in July 2019. Okay, July 2019. An immediate payment of this compensation of this amount lead to removal of funding for health, social welfare programs. We don't have money, therefore we cannot pay for that. That's what the Pakistan said, to put it simply. And Pakistan is not wrong. This is a IMF document, IMF website, which says that IMF offers certain amount of money. It's not really a certain amount, it's a huge amount of money, 6 billion, for Pakistan because of these reasons. And at the same time, almost at the same, well, let's look at the date. July 3rd, 2019, IMF decided to grant this amount of money for Pakistan, and tribunal decided almost at the same time to oblige Pakistan should pay this amount of compensation to a private company for its breach of international obligations. Therefore, the money comes from IMF to Pakistan and then to the private company, this amount. For Pakistan, this is not acceptable, but the tribunal said, well, the market value of an investment immediately before the expropriation impending expropriation become public knowledge. There's no need to decide whether the result is based on compensation provision. Well, anyway, the tribunal said that they simply applied customary international law, and then Pakistan is held to be obliged to pay that amount of compensation. Of course, the International Law Commission has considered this kind of situation when drafting its rules. In 1993, a few years before the adoption of the final text, to be more precise, 8 years before the adoption of the final provision, the ILC considered this article, at the time Article 6 bis reparation. The main text is not really different. What's interesting is in the commentary. In the commentary, ILC at that time in 1993 said there may be other equitable considerations that might be taken into account in providing full reparation, particularly in cases involving an author state with limited financial resources. If the states which have committed the internationally wrongful act has only limited financial resources, maybe there may be cases where the obligation of full compensation does not apply. There may be such instances. That was a possibility envisaged by the International Law Commission at that time, 1993. Yes, please.
It's heartening to see that, but I think the impact of that is, to a certain extent, neutralized by the subsequent sentence, isn't it? But only to the extent that such consideration can be reconciled with the principles of equality of all states before the law.
Of course, yes. This is not a paper written by an individual, by a single individual, but a group of 50 group of people. You have to have some compromise in the groups, and that was a result. But anyway, at this time, 1993, the International Law Commission considered this possibility, and in 1996, a proposal was made where, according to which in no case shall reparation result in depriving the population of a state of its means of subsistence. That was a draft discussed in 1996 by the International Law Commission. Again, in the commentary, they said that there are examples in history of the burden of full reparation being taken to such a point as to endanger the whole social system of the state concerned. For example, the context of peace treaty, a peace treaty, not a specific treaty, but a peace treaty, following the defeat of a particular state. And that was said in 1996, and in response, of course, you see these two states. France, paragraph 3 should be deleted. That's what France said. The paragraph 3, in no case shall reparation result in depriving the population of a state. France, according to France, this paragraph 3 should be deleted. According to Germany, well, there may be such cases if a peace treaty obligation to compensate in accordance with the peace treaty put the subsistence of people in danger. Therefore, yes, perhaps we have to seriously think about paragraph 3. Of course, this is clearly explained by the historical experience of Germany and France. What happened 100 years ago? Then the International Law Commission continued to discuss. The United States proposed that paragraph 3 is without support in customary international law. Therefore, no state practice, no opinion juris, which would justify paragraph 3. Therefore, according to the United States, this paragraph 3 should be deleted because it does not reflect customary international law, according to the US. There was a member in the International Law Commission who said that compensation should never have the effect of depriving the population of a state of its means of subsistence, which would be excessive. Therefore, this member, she was in favor of maintaining this paragraph 3. But the result is, of course, we know the consequences. There's no justification for requiring the victims to bear the loss, right? That was the third report with James Crawford, which was finally adopted. Of course, you know that James Crawford was the special rapporteur of the State Responsibility Project. And he said there's no justification of requiring the victims to bear the loss. Well, in the case of wrongful act, there is a victim, and the victim shall be compensated for, and the victim is entitled to receive a compensation which would wipe out all the consequences of wrongful act. And if you consider that, if you argue that the wrongful state, a state which committed the wrongful act, may not be obliged to pay full compensation under certain situations, you mean that you are requiring the victims to bear the cost. And this is not acceptable as a matter of legal principle. That's what James Crawford said, and that's what was accepted by the International Law Commission. But there could be, of course, a possibility of an agreement. And this is, to a certain extent, understandable. Now, this is one of the well-known cases before the International Court of Justice, Diallo, between Guinea and DRC, Democratic Republic of the Congo. State-to-state relations. Therefore, according to the International Law Commission, the obligation of compensation simply applies, right? Because it's a state-to-state obligation, state-to-state relations. The ILC said that the obligation of compensation, full compensation, may not be applicable to the relationship between state and non-state actors, like individuals, companies. But here, the dispute is between a state, Guinea, and another state, the DRC. Therefore, between state to state, of course, the principle of full reparation shall apply, and that's what the International Law Commission said. But this is not in reality a dispute between state and state, since this is a case of diplomatic protection. Diallo was a citizen of Guinea, claims that he got a problem in Democratic Republic of Congo, and he asked his government, the Republic of Guinea, to represent him before the International Court of Justice, and the government accepted. The government put a claim, presented the claim against the DRC, and the International Court of Justice decided partially in favor of Guinea, but in fact partially in favor of Mr. Diallo, who is of course an individual. Therefore, the law applicable between states and law applicable between states and the individual is not really easy to be distinguished, right? Because if you go to the investment tribunals, the claimant is an individual or a company, private person, and the respondent is the state. Therefore, it is clear that the legal relationship is between a state and non-state. But here, technically speaking, the dispute is between state and the state. But in reality, it's a dispute exists between the state and the individual, who is Mr. Diallo. So from a purely technical point of view, there's no problem in applying the principle of full compensation. But if you look at the reality of the case, maybe you put that theory into question. So to put it simply, you are obliged to pay compensation in order to wipe out all consequences of you had done in breach of international law. The principle is simple, but do you think that the International Law Commission was right as a matter of international law, not as a matter of policy, but as a matter of international law, to delete this paragraph 3? This is not in the final draft, right, in the final text. The paragraph 3 does not exist in the final text. As a matter of international law, do you consider that international law was right to delete this paragraph 3 or not? Of course, you have to think about the wrongdoing state, which has limited resources, but at the same time, you have to think about the victims, which may be in a similar situation. So what do you think of this? There are historical examples. Sorry. Oops. The best example is, of course, here, France and Germany. What happened after this First World War? There is a bitter experience in Germany. Therefore, Germany was rather in favor of maintaining paragraph 3, but France was clearly against the maintaining paragraph 3. But taking into account that kind of examples, of course, and other examples, we have seen what Tethyan decided. What do you think of this? Was the International Law Commission right in deleting the paragraph 3? Any comments, any opinions? From Bart. Yes, please.
I think since nobody wants to take the floor. Okay, I think this is an important paragraph 3. It is quite important because you can't be blinded by just one principle and apply them without considering an individual country's economy and society. I think it's important. We've seen this in our case, as you explained. In case of Pakistan, we had to settle this award for $1 billion US, and then we also had to give the concession back to the original claimant. So we've seen that in Pakistan's case, but I would like to step a bit deeper into history. Now, Treaty of Versailles happened, and the Germans were asked to, I think, pay around 132 billion gold marks at that point in time, which is roughly 44 billion US in today's terms. And I think we saw the consequences of what that could bring. This blind vendetta. Of course, Germans had been responsible for what happened and the destruction during the First World War. But I think in my experience as a diplomat, as a lawyer, I've never seen any treaty worse than the Treaty of Versailles. And I think what that led to is Nazi Germany. What that led to was hyperinflation in Germany. What that led to was another terrible war in less than 2 decades. So I think the application of Cherzo, the principles enunciated in the Cherzo factory case, now they might be inspired by noble ideals, and that everybody is supposed to make the whole for all the wrongful acts, but I think the problem lies in the selective application and blind application, where you do not take into account what impact that could create in a particular society and a country. Thank you.
Thank you. Any other comments, opinions? The possible, yes, please, go ahead.
Thank you, Professor. I think the Commission was not right to delete that provision because ultimately the final beneficiary of the right are the individuals. So deleting such provision, it may be disastrous to the population of that country where the full reparation is required. Thank you.
You, if you consider that the Commission was wrong in deleting this, how would you respond to James Crawford here? There's no justification for requiring the victims to bear the cost. This is a really, of course, a touchy, quite difficult question. I mean, I have to confess that I have no answer to this, personally. But yes? Comments?
We could qualify this with something. I mean, of course, this has to be agreed in principle, but then it has to be qualified, provided something. I mean, lawyers are very smart people, right? They can actually dilute the impact of an article just by qualifying it with some word.
Yeah. So that's what he says. You know, if the parties agree, of course, you can do anything. You're a sovereign state. As far as you agree, you can do reduced amount of compensation, or you can even abandon the right to require compensation. It's up to you. But as far as there's no agreement, as long as there's no agreement, then the general principle applies. General principle is the full compensation because there's no justification for requiring the victims to bear the loss. That's what the James Crawford said, and that's what the International Commission finally accepted. But the question is, of course, yes, as a moral principle, that's right. But as we have seen today, the general principle, general rules, as embodied in the LCOR Articles of Social Responsibility, are extremely well drafted, neatly drafted, simple, clear, easy to apply. Therefore, it's widely accepted, applied in the world. Fantastic. However, since it is simple, they do not necessarily cover all the situations, all the complex situations, all the complexities of the real world. We have seen just 3 examples today. Okay, as a matter of general law, perhaps we can apply CWA or rules embodied in CWA. But in reality, there could be cases where we have to think about perhaps not modifying or amending, but in applying the principles with some considerations, some perhaps modifications, but how to achieve that possible modifications or introducing exceptions is a really difficult question. But thank you so much for joining and listening my lecture and joining on this discussion. I just wanted to explain that the textbook approach of international law is fine, but of course, there are many exceptions, many difficult situations where the general principle cannot be applied directly or as such. And I hope that this kind of information would help in the developing your career in international law. Thank you so much.
Thank you very much, Professor HAMAMOTO, for your insightful lecture using various kinds of concrete examples. Well, we'll take a short break and start the next session, which is a panel discussion at 11 a.m.